So I'm Justin William, based in Seattle, and I'm going to talk to you about asset protection and medical decisions today. So under this COVID situation, there isn't really anything new on this field, but I think it's a reminder for everyone that we should prepare ahead. When we talk about asset protection, there's a few aspects. So who do we want to protect it from? And that includes taxation and from litigation, creditors, and also potentially your family members, your ex-spouse, for example. And how do we achieve that? So sometimes there are tools, and sometimes there are things like trust, or you can protect your asset in the trust or using the company, because third-party legal entities allow you to separate your personal property from that entity. And of course, there's a downside to everything. So what do you lose? It costs money to administer a trust or a company, and also it could potentially hurt feelings if you're talking about things like prenuptial agreement. And that's the balance that you need to weigh, whether you want to do that or not. So I want to talk about community property. So community property is a doctrine that your property acquired after marriage belong to both of you. So this includes income, but it does not include anything that you acquired beforehand or the derivatives, such as if you own a house prior to your marriage and you got married, and you are still receiving rent from the house or property gain from that. Because the house you own a house before the marriage, so it still stays separate property, but you must be careful about that. You have to make sure that the rent from the house, for example, is kept in a different account. A famous case is the founders of the See's Candy Company. They in the past they have inherited a house, and it would have stayed separate, but they were commingling the funds from the house, the rent from the house, with their own personal funds, and to the point that the court decides they could no longer distinguish whether the money belongs to the money came from the house or from the business. So at that point, the court says that the house essentially becomes community property at that point. So this doctrine is mostly on the West Coast and also down south. Only 10 states in the United States follows this. And the other thing is, are things acquired during marriage always the community property? The answer is not necessarily. So I talked about earlier, you could receive a gift. For example, a gift from your parents to you, that is a gift to you and not to the community. And also, you could buy a house, for example, and have your spouse agree to quit their interest in that property, so that it stays your personal property, your personal separate property. And there are some tools that can help protect your assets. So you can have a pre-nuptial or post-nuptial agreements. I think most people have an idea of what the pre-nuptial agreements are. Post-nuptial agreements are agreements that you made between a spouse after you got married. But you could do that. You could do that for a variety of reasons, such as you want to make sure that if anything happened to you and your spouse marries someone else, you don't want to lose the inheritance that you want eventually going to your kids to your spouse's new spouse and lose it. So you could make arrangements for that, for example. And you could have legal entities limiting liability. By that, I mean the companies, such as limited liability companies. You could get insurance This includes your personal liability insurance like an umbrella policy, or your professional insurance like errors and omission, or life insurance, health insurance, or long-term care. All these things, something help protect you from lawsuits or help you pay for lawsuits. The other ones help you pay for your healthcare, which is very expensive. And the other way to go about it is you can do a tax claim and estate planning by giving away your property during your lifetime, so it reduces your estate tax. You can put it in the trust. So what is a will? So people, I think most people know, have an idea of what a will is, but by definition, you specify how you want to distribute your property and money to your heirs, the person that receives them. If you don't have one, most states, all states have an interstate statute to describe how to distribute the property. For example, if you have 3 kids, you could say you want to give all of them to one of the kids and don't give anything to the other 2. That is legal. But if you don't have anything like that, most states would do things that would go by their interstate statute. It usually goes like this. For example, if you are married and you have kids, half of your personal property would go to the spouse, and the other half will be divided by your kids. And if you don't have kids, you don't have a spouse, it could go upstream. It goes up to your mother, your father, and then goes down to your brother, your siblings, if your parents are not around, for example. A will controls properties that are not already designated. For example, if you have an insurance policy that you would say who the beneficiary is, or if you have investment accounts, they could have a pay on death beneficiary that transfers that account to them. And if you are married, there's a thing called mutual will. It also helps with the situation I described earlier, where you worry that your future spouse is going to end up taking all the money. You could designate that when one of you die, the distribution of the will kicks into place. And you want to make sure that you follow the formality. So not all states have this. So some states have allows recordings. Some states don't. But for written will, you usually have a requirement that it either needs to be witnessed by 2 disinterested parties, which means there are people who are not on the will or have anything to do with your money to be the witness, and it has to be notarized usually, because you want to be careful with that, because you don't want people to come and challenge your will and say, oh, this one of the witnesses is your daughter, that she's the interested party, so this will is not valid. And you also want to, once you have one, you want to periodically review your will, because situations could change. Your financial situation could change. Your family situation could change. And if you, for example, if you draft up a will and you did not, you specify your existing existing children, but you end up having another children afterwards. It could be a future born, or you adopted them afterwards. The state law usually would try to distribute the property evenly, so that person also gets covered. So about business entities. So if you have since this is a chamber of commerce, I think a lot of us are doing business one way or the other. So the usual type of business entities that allows you to to shield your liability are limited partnerships, corporations, and limited liability companies. These entities separate the company from you so that when the company gets sued, or when you personally get sued, it does not affect the other part. So when they go after your company, they can get everything in your company, but they cannot touch your personal house, for example. And so to that end, you also want to consider having a multi-entity structure. So if you own a commercial property and you run your business in that property, it might be easier for you to just hold the property and the company under the business, but it's probably better idea to make two companies. So you have one company hold the real property, and you have the other company hold the business, and you pay the rent. You pay the rent to yourself. Now the benefit of doing this is that if one of the company gets sued, like in the personal situation, they cannot get both. So if they sue your restaurant, they cannot reach your real estate company, real estate holding company. But one thing I want to be careful with is the concept called the piercing the corporate veil. This means that if you have so similar to what I talked about earlier, where your rent commingles with your after marriage fund, you also don't want to commingle your business with your personal life too much. It's tempting to use the company card for your personal use and also use the company fund to go dine out because of tax benefits. But if you ever get sued and they found out that you basically are using the company's money for your personal life, then you have the problem that they are going to say, okay, so the company and you are one of the same. So whatever the company owes other people, you are personally liable to, and you don't want to be in that situation. So make sure you separate your personal life and your business life as much as you can. So different type of insurance, professional insurance, usually they are required for your profession, and liability insurance, life insurance, healthcare insurance. We talked about this a little bit earlier. So you can talk to your insurance agent about what type of insurance is available to cover your needs. So trusts are a fiduciary relationship where the trustee owns property on benefit of the beneficiary, all of them used to minimize estate tax and offer protection. So one of the benefits it provides over will is that it does not go through probate. So people don't know what you have. And it avoids your kids, your spouse, or their future spouse's abuse. And it also shields that property in a trust from the creditors. So if any of them ends up racking up a big bill that they cannot afford to, but since this property is held in the trust, their creditors cannot get to that property. The benefit would be that if you have a trust for all your family members, one person's problem would not affect the other people. And also you could consider that for government benefits like a Medicaid asset protection trust. So Medicaid has every state has their own Medicaid program, but basically, usually the asset you cannot own more than $2,500. So you want to put your property in the Medicaid asset protection trust so that you still qualify for Medicaid. And there's two types of trust that generally there are many types of trusts for specific situations, but generally there are revocable ones and irrevocable ones. The revocable ones are the ones that the settlor, which is the contributor to the trust, retains management power to that trust. It provides you more flexibility. It might be tempting because you want to be able to control your asset. But the downside is that since you can control it, it does not offer as much protection as the irrevocable ones. So in the irrevocable trust is a trust type that you essentially put the property in the trust and says, okay, I'm done. Somebody else come and manage this. And since somebody else is managing that and not yourself, it offers the strongest protection from liability, and also provides tax benefits. So for business like an LLC that we could use to shield our liability, it could also be used as a estate planning tool. So by that I mean, for example, if you want to give the house to your kids, so the federal tax allows you to give away $15,000 every year without having to pay tax on it. But if you want to give your house away fractionally like that, it might be a lot of trouble to draft up a deed every year just to give a little bit away. So what you can do is you can put the house in the LLC, hold it in the LLC. And by doing that, you can instead of writing a new deed every time you want to give something away, you can just give shares of the company away. And the other benefit of that is you could pay less taxes on it. But what you want to do, so the benefit of doing that is you have control of the company as the manager, and you can have your kids or your heirs as the members of the LLC. And by doing this, since you are in charge and they are not in charge, the shares you give them have no controlling power, no voting power. They can be given at a discount rate. So, for example, if you set up $1 million house under 100 shares, so each share is worth $10,000, but you can give them away for less than that because that share has no control over the property, and nobody will be interested in buying no control of a house anyway. So you can value that share at a discount, say usually 30–40%. So instead of getting 1.5 shares per year, you can give you can give more shares per year and transfer that property faster. Now, I want to talk about decision-making powers in given this situation, because because this could be an issue for anyone under the circumstances that if you are hospitalized, you are unable to communicate, what happens? So there are two types of core-imposed substitute decision-making. One of them is called conservatorship. This is for people who are not completely incapacitated. Like they are able to make decisions, but they don't have the ability to do things. So usually this could be for elderly person that are not physically capable, that want someone to take care of their life for them. The other type is called guardianships. These guardianships are for people who does not have the mental capacity to make decisions. So, like for example, maybe dementia or diminished capacities that they could not make decisions for themselves. And this is for people who also did not make any other voluntary arrangements beforehand. So what are the voluntary substitute decision-making powers? Could have a representative payee like your Social Security Administration, or you can have joint tenancies like in your bank account, for example, that either of you can have control through that account. You could give someone the power of attorney. Also, you could give someone the medical power of attorney. And you could have what's called a living will, or sometimes called an advanced healthcare directive or directive for physicians. This is basically a healthcare decision you make beforehand. And of course, we talk about you can put in a trust or use a family LLC to help handle your businesses. So what's a power of attorney? Power of attorney creates a fiduciary relationship between the person, the principal, and the agent. It could be general or specific. It could be durable or springing. Basically, a durable. I'll talk about it more later. But durable power of attorney has a, as the name implies, it has a longer validity. A springing power of attorney is one that comes into power not when you sign it, but when something happens. For example, if you are determined to have no capacity to make decisions, and you could have multiple agents. You can assign one person to be an agent. You can assign multiple people to be an agent. Of course, that's not ideal, because what if you have an even number of agents and they could not decide, they could not agree on something? And you could have a substitute agent where if one of your agents does not want to perform their duty, the substitute agent can come in and do that. And the power of attorney can be terminated by death, revocation, or expiration. Power of attorney does not substitute a will, because when you die, you no longer have any power, so you could not give that power. You won't be able to have someone exercise your power at that point. So what's a durable power of attorney? The power of attorney comes in many forms. Sometimes it's a one-time deal. So, for example, you need to go sign a contract, but you are unable to in person. You can give someone a power to sign a contract for you, and that's a one-time special power of attorney. The durable power of attorney is the one that continues to exist. For example, if you are determined to have a diminished capacity, that person can still exercise your power of attorney. And the definition for incapacity is the inability to manage property, business, personal, or healthcare affairs because you have an impairment that prevents you to receive and evaluate information or make or communicate decisions even with the use of technological assistance, or is an absentee or unable to return to the U.S. The definition for absentee is usually that comes in during time of war, that you're missing in action, you are in an internment camp, or you are a prisoner of war, that there's no way to get your consent to be, there is no way for you to actually be present and be able to communicate your intent. So there are many specific power you can communicate. You can grant to the agent. You can have them make healthcare decision for you or the minor children. But in Washington State, there are exceptions that if amputation, for example, shock therapy, and mental health procedure that includes restraint, like a mental institution, those things are not able to do it for you. And but you can also have them be able to buy or sell things, like they can buy a car or sell your car for you, but they can handle your business, or they can collect debt for you, they can invest your money, or other financial matters. And also they could sue on your behalf. Now, can you just say, I want to give them everything, every power that I have? You could just say that, but then some powers has to be specified specifically. So the power to make gifts of your money or to other property, because you don't because you don't want the agent, we don't want the agent to be able to just give money to anybody they want. And the power to change your company property agreements and to designate beneficiary of your insurance policies. Now, so the property agreement that also plays into the Medicare part, because if you are unable to change the property setup for your spouse, then they won't be able to apply for Medicaid, for example. And some parts just cannot be given away, so they cannot vote for you, or they cannot make or alter in the will for you. Now, so what's a fiduciary duty? So fiduciary duty applies to the four types of people we talked about. It is the conservator which is the one doing your conservatorship for you, or the guardian who is the one doing your guardianship, or your power of attorney agent, or your advanced medical care directive agent. So this is the very high level of duty. This person is acting for the principal, which is you, your benefits, and they must disregard their own interest in that and take yours over them. They must act in good faith in the biggest interest of the principal, which includes the duty not to engage in self-dealing. So if you have an agent that, for example, is paying themselves money, that could be a problem. But if you want to, of course, you could have specified that in your power of attorney that they do get paid, for example. And the problem of that is also if they make a decision, whether they did it out of good faith or not, since they were representing you at that point, if they make a mistake, you are going to be liable for them. So you want to be careful when you choose an agent. Now, the deeming will, or the advanced medical care directive, it can be used to withhold treatments. So usually when you want to do this when you are terminally ill or unconscious, and any treatments not going to cure you, it's only going to prolong the process of you dying. A lot of times you want to do this is because you don't want to rack up a big medical bill for your family, and or maybe you just don't want to continue to suffer unnecessarily. So it includes withholding artificial nutrition, artificial hydration, artificial respiration, or CPR, or artificial ventilation, other resuscitation measures, mechanical or chemical ones. The surgery that only prolongs your life and does not cure. For example, a surgery that removes a cancer, but it does not cure you. You only reduce the symptom. For example, dialysis to help with your lost kidney functions, blood transfusion to replace blood are lost or contaminated, and medication to prolong life, and not pain management. So this is important that you don't need medication that only prolongs your life and not cure you, but you still don't want to be in pain, so you want pain management medicines. So planning a medical care directive is pretty important. You want to talk about you want to talk to your patient about their goals, and you want to make sure you document everything. And you want to review and update the clinic when their health situation changes. That could also affect that would definitely affect their decision. So a lot of times, I think the statistic is less than half of the living wills are being enforced, because there's a lot of times the family wants different things than the person themselves. So when you roll one up, you want to be clear about the type of treatments that you do not want, give copies and to agent and treating doctor, and make sure your doctor has a copy, and then discuss with your family about your wishes so that they don't have an issue with that. And this is an example of advanced healthcare directive. So quick note on capacity. So capacity is basically a question of, do you know what you're doing when you make this decision? And this could have a problem because there could people who wants to challenge your decision on your will or your POA could say that you do not have the mental capacity to do that at that point. So so the important part is we want to plan everything early in advance, as early as possible, so that your capacity is not going to be an issue. You want to build in a safeguard so the PO is not abused. You can have a second agent to oversee, basically like an auditor to the power of attorney, and make sure you have a good idea of what your healthcare goals are. Okay, thank you.